You understand? You're going to be on zero tolerance. That means no mistakes on probation. All right, Jameldrin Willridge, Mr. Lewis, Ms. Malfino. Those are Alvin's, the last one. All right, are you Jameldrin Willridge? And so before we go forward, Mr. Lewis and Ms. Malfino approached about possible solutions to the issues that we have here with Mr. Willridge is on probation. In 3 cases, there was a new offense that occurred while he was on probation, but before he went to ISF as a part of that probation. And what I want to know before I consider any type of continuation of probation is couple, I guess, number one, how do you have any idea how he did, Mr. Kitchen? I guess, and before you go forward, would you raise your right hand? You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
Any issues with regard to behavior at ISF that you were aware of?
None that I'm aware of.
Okay. When did he get back from ISF?
I'm not sure exactly. I did not receive Mr. Willridge under my supervision until September 26th of last year.
Okay. And how has he done from then until he was incarcerated on this?
And he was very cordial with me. We've had cordial bit surprised by this and the other stuff that's been going on with it.
Okay. Any positive drug screens, any issues at all since you had them in September? Okay.
May I just ask him one question for the clerk?
Of course, please.
Mr. Kitchens, you brought to my attention, and I think the clerk has also sent it to Mr. Lewis and myself. His behavior in jail is less than to be desired, correct?
Yes, that's correct.
And would you characterize that as his association with those individuals who the court is very well aware are in jail, that is a different side of him than you saw while he was out on probation under the guidance and eye of the court and his family?
That's correct.
With the understanding, I'm sorry, Judge, if I may, that obviously Mr. Wilders is facing quite a bit of time from this court on a revocation. And would it be your intention, along with the court and myself, to make it clear to him that if he is given this opportunity, that if he comes back before this court, that he's not looking at maybe what he would be looking at today, but probably 3 times in advance of that amount of time?
Yes.
And do you think he is capable of and understands the seriousness of what it is he's facing?
I believe he does, yes.
From your interaction with him.
Okay. Well, Mr. Willridge, this is tough for me. Because you've been given a couple of opportunities and this would be another opportunity. And I don't know. I don't want you back in here. I don't want you to violate. I want you to be successful. You've been on a decent path. But what you did and thought you got away with, things catch up with you. Right. And so that one's a 2 to 20 case. I could revoke you on your ag robbery and send you to prison for the rest of your life today. The rest of your life. And based on the history and what's been going on, some big fat number is probably what you deserve. And so I don't know how to be any more clear than if I give you this opportunity with what your attorney is working out with the district attorney, that Mr. Kitchen sounds like he's willing to work with you. And if I go along with this and leave you on probation and put you on a new probation, if you're back in front of me, there will be absolutely no argument about continuing probation or some low end of the punishment range. That won't be what's happening. Do you understand? Mm-hmm. You're going to be on zero tolerance. That means no mistakes on probation. You've been on it long enough now to know how to be successful or not on probation. And if you just live your life right and do what you're supposed to, that shouldn't be a problem. It's only hard if you're doing the wrong things. Does that make sense? Yes. All right, y'all can do the paperwork.
Thank you, Judge.
Thank you.
Lewis, on Jameldrin Willridge. Oh, you just did paperwork on the new case? Okay. So is it the state's intention to dismiss the MTRPs?
With court's permission.
Yeah.
Whatever you prefer.
That's fine. No, I don't care which way we do it. If you want to dismiss them, that's fine, or we can go through them and I continue, but either way, it's kind of the same.
Okay.
All right, again, you are Jameldrin Wilridge, correct? Speak up for me. And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Wilridge, in clause number 25, DCCR 1804, you're charged with the second-degree felony offense of burglary of a habitation from August 29th of 2024. And how do you plead to that charge?
He gets,
Are you pleading guilty freely and voluntarily?
yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow this agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And the agreement shows that this is for a 10-year deferred probation. What about, this is the one with the shoot, what about restitution? Right, this is the one where he went.
Yes,
It's all the shoot.
It was 100,
It was a lot.
probably 100 pair of Jordans. You would think I would know how much those cost.
So here's what I
Yeah.
might do, just so that I have everything that I need, go ahead and get a pre-sentence report.
Okay.
You can get with them, get
Yes,
a
ma'am.
restitution amount. You are going to be required to pay restitution. So if you still have some of the shoes, find them, get them, talk with Mr. Lewis. They can be returned, so you don't have to pay for
Okay.
them. He did get it all back?
I'll
Okay.
confirm that. Your
So
Honor.
we're gonna just get that confirmed between now and then, and I do want to go ahead and kind of get an update so that the new case is in a PSI, since we don't have it, the new case. I don't need a, little update on the probations, for sure, double check on ISF and how that went, but it sounds like there's not an issue, but I just want to make sure. And so do you also understand, Mr. Wilridge, if you're not a US citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence Mr. Wilridge is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can just have everything in front of me that I need, make sure there's no other issues, and then we'll go forward with sentencing at that time. Any issue with me releasing Mr. Wilridge since he has been doing okay?
No, Judge, wouldn't mind if I just hold on those MTRP dismissals until that sentence
Yeah,
date.
I
just
think
in
that's
case
what makes
something
it.
pops up.
I think that makes sense. So, Mr. Wilridge, what I'm going to do in your case is reduce your bond to $1,000, but I'm going to make that a personal bond. What that means is that you don't have to pay the money. You will be released today. So what I need to do though is, on those motions,
Unless it would make it easier for you if I just dismiss
just do personal, I can just set personal bonds on all of them. So I'm gonna set personal, so on all 3 cause numbers that you're on probation for, which is 18-28743, 18-28744, and 18-30139. I'm going to set bonds on all of those where the motion to revoke are pending at $1,000 also, and make those personal bonds. So what all of this means is that you're going to get out today without paying any money. Some very, very important things though, between now and when you come back for sentencing. Obviously, you're on probation still for the other 3. You need to report to probation for 2 things. 1, because you're still on probation. 2, so that they can do that updated pre-sentence report about the new case and kind of how things are going right now. Okay. If you don't go straight to probation when you're released to do all of that, then you run the risk of me not accepting this plea agreement. Things could obviously be much worse. You understand? Speak up, please.
Yes, ma'am.
Also, if you're arrested for anything between now and when you come back, you run the risk of me not accepting this plea agreement, and then you've got those motions pending and things could obviously be a whole lot worse. You understand that as well? And so, was there a co-defendant in the burglary? Or no? Okay.
I don't think so.
So I am going to order as a condition of your bond also, and it will be a condition of your probation that you have absolutely no contact or communication with Jasmine Adams as the owner of that apartment. And that apartment was where? Do we have an address?
That apartment was located
I can probably get
at,
that.
4165 Old Dallin Road. It was apartment 91, but I would suggest.
So,
you stay away
yeah,
from the
so-
entire complex.
Correct. That's what I'm gonna do. So you cannot go anywhere near 4165 Old Dallin Road. Any of it, none of the apartments. Do you understand? Anything else that you feel like I need to, order as a condition of the bonds?
I'm just double checking for any type of co-defendant. No, Your Honor, I don't believe so.
Okay. All right, then we'll see you back at sentencing. Again, make sure as soon as you're let out of custody that you go straight to probation. Okay. I need you to answer out loud for the
Yes, ma'am,
record.
I understand.
Thank you. And then in cause number 25, DCCR 1466, you're also charged with assault on a peace officer. This one is from August 17th of 2024. The first one that I read out was actually from May 5th of 2025. So the second one, same thing, is a second degree felony. If you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And in that case, that means that if you went to trial and you were found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand that?
Yes, ma'am.
And then in cause number 25 DCCR 1468, you're charged with assault on a peace officer, and this is from that same date of August 17th of 2024. Again, if you're found guilty by a jury, the same punishment range applies, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then the last case is 26 DCCR 0120. You're charged with possession of a controlled substance, a state jail felony from August 8th of 2024. And in that case, if you were found guilty, the range of punishments between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I have here on the tablet plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 8-year term in prison and on all of those assault on a peace officer cases that would run at the same time concurrently. And then a 2-year sentence in the state jail prison on those two.
The offer was actually we would dismiss the state jails, Judge.
Okay, so there would be a dismissal in the 2 state jails with, I'm gonna make that notation.
Because I just signed paperwork refusing 2 years with both of those.
You did, so obviously the bigger cases are the 8-year terms. So what the offer is, and so that we're all on the same page, it would be 8 years TDC on the 3 assault on a peace officer cases with dismissals in the 2 state jail cases. Does that change your mind?
No, ma'am.
Okay, so you have every right to reject.
Probation.
Hang on. So you have every right to reject those offers. I just need to make sure that you understand what the possible consequences are if you go to trial,
Yes, ma'am.
what your options are if you wanted to enter a plea of guilty, and you understand all of that.
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set for trial. Ms.
Can I
Mouton,
get the lawyer?
just listen. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am. I thought you was trying to make me keep him.
Well, it wouldn't be the worst thing because he's one of the best lawyers we
I
have.
understand.
So, Mr. Rojas, you're released. And Miss Mouton will give you a new attorney. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Also, hold on, come back. Mr. Smith, do you anticipate there would be any reason for that offer to change?
Judge, I thought that was a very generous offer.
So I do want to make sure you understand that just getting a new lawyer doesn't mean things are going to change. The offer is what it is. And so, there's not going to be any change just because there's a new lawyer.
I've seen the tapes and it's not enough on the tape to show that I deserve 8 years.
All right,
I
but that'll
haven't
be
gotten
up
in
to,
trouble in 20 years.
that'll be up to a jury. That's what juries are for. You can go back with the bailiff.
That's it.
There are moments in a courtroom that the legal system doesn't design for, but somehow produces anyway. A judge facing a man with multiple felony probations and a brand new burglary charge, a man whose behavior in jail was described as less than desired by the very officer there to help him, could have simply done the math and signed the order. She didn't. Instead, she stopped. She looked directly at Jamal Willage and said what most judges put in formal language: "You have been given chances. I could end this right now. Not hypothetically right now. Prison for the rest of your life today." What makes that moment worth watching isn't the threat. Judges issue warnings every day. What makes it worth watching is what came after it. She chose not to. She saw something in his compliance, in his record outside of custody, in the testimony of his probation officer that led her to give him a personal bond, release him without paying a dollar, and send him out that door with one final instruction: go straight to probation. Meanwhile, in the same courtroom earlier that morning, a different defendant sat across from the same judge, looked at an 8-year plea offer for assaulting peace officers, and said the tape wasn't enough to deserve it. Same judge, same morning, completely different result. That contrast is what the law actually looks like in real time. Whether Willage walks the line or walks back into this courtroom is a question only time can answer. But one thing was certain in that moment: the judge made her expectations perfectly clear, and there are no more second chances waiting on the other side. Justice doesn't always look like a gavel coming down. Sometimes it looks like a door opening and a person walking out knowing exactly what it cost to get there. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.